All right, it's 6:30. Good evening, everyone. Thank you for being here this evening. This is the City of Garden City Planning and Zoning Commission meeting on Wednesday, April 15th, 2026. Ms. Field confirming audio and visual is working.
Visual is definitely working. Audio has not been confirmed one way or another.
Okay,
There's no one in Zoom to confirm with.
sounds good. Jenna, did you want to confirm that or?
All buttons are on. Yeah, I have it recording.
Okay, we're recording?
Yeah.
We're good? Okay.
Chairman, to answer that, as long as we're recording, if there's no one on Zoom, then I don't think that it matters.
Okay, if someone jumps on, we can check it at that point, but as long as we're recording. We'll now call the meeting to order. For the record, we have Commissioners Shepard, Brown, and Smith present, with Commissioner Bickerton being absent. We'll stand for the Pledge of Allegiance. This commission provides for a public hearing for quasi-judicial administrative land use decisions, appeals, and legislative actions specific to land use regulations. The commission makes final decisions on conditional use permits, variances, and appeals, and makes recommendations to the city council for subdivisions, rezones, annexations, and code or comprehensive plan amendments. As a matter of order, the format for the public hearing will follow the following process: presentation by the applicant, presentation by city staff, public testimony, rebuttal testimony from the applicant, and then discussion among the commissioners, and then a decision. If you wish to give public testimony, there are some general rules to abide by. No person shall be permitted to speak at the public hearing until the person is recognized by the chair to do so. The commission will not address those who speak out of order. If you have questions, you may ask them during your turn for the public testimony, and the applicant can respond to them during the rebuttal, or the commission can ask the question of staff during their discussion. There are sign-up sheets at the front. If you wish to give testimony, please sign up. I do have a number of sign-up sheets already, so we'll need to check before we begin on any topic to make sure that there's no other sign-up sheets that have been provided. Again, if you wish to testify, please sign up to do so. No person shall be permitted to testify at the public hearing unless recognized to do so. And if in person, such person has signed their full name and written their residential address on the sign-up sheets. If you're going to testify, please clearly state your name and address into the microphone at the podium. Are there any changes to the agenda at this time?
Chairman, none by staff.
All right, thank you. We will go ahead and begin with the consent agenda. The consent agenda includes items of business which may not require separate discussion. From time to time, we may move an item to the consent agenda. At this time, I see that there is one item that could potentially move to the consent agenda. This item is under new business A, VAR FY 2026-001. Kristen McNeil with Gibbons Persley is requesting a variance to Garden City Code 8-2B-3 to allow an encroachment of a structure outside of the 10-foot maximum habitable space setback and within the 20-foot sidewalk setback. Is the applicant present?
Yeah.
All right, thank you. And have you had a chance to read the decision document and the conditions of approval?
We have.
All right, thank you very much. Staff, is there any reason why you would see that this would not be moved to the consent?
Chairman, no.
Thank you very much. Is there anybody here from the public that wishes to testify on this one item? Again, this is the variance. It is not the conditional use permit or the text amendment. Is there anybody here to testify on that item? All right, seeing none, then commissioners, is there any reason that you have on this item not to move this to consent?
No.
No.
All right, thank you. With that being so, then when the time's appropriate, we can entertain a motion to include that onto the consent agenda. Other items on the consent agenda, item A is approval of the minutes from March 18th, 2026. Let the record show that I was absent from that meeting and not be voting on that item, but we'll be voting on the other items contained in the consent agenda. Item B CUPFY 2026-006, a conditional use permit. This is continue the public hearing to a date not determined. Item C is SUBFY 2026-0001. This is continue the public hearing to May 20th, 2026. Any other items for discussion on the consent agenda? Hearing none, then I will entertain a motion. And again, we will be entertaining a motion as well for the movement of that item onto consent.
Mr. Chair, I move that we approve the consent agenda consisting of A, B, and C, and with the addition of new business, section A, VAR FY 2026-0001.
Thank you, Commissioner Smith. Do I have a second?
I'll second.
We have a second. Thank you. Any further discussion on this? Go ahead and take this to vote. All those in favor say aye. Aye. No? The ayes have it. Thank you very much. All right. Thank you. I appreciate it. Thanks for stopping by. Yeah. All right. We will now move on with new business, the public hearing, action items. Item B is CUPFY 2026-009, conditional use permit. Julie Miller with Studio H Architects is requesting a conditional use permit to encompass future uses in an effort to expedite tenant occupancy at 521 East 41st Street, located in the C2 mixed use commercial zoning district with a development agreement. Again, just as a matter of order, the format for the public hearing will take the following order. There will be a brief introduction, presentation by the applicant, city staff report, then the public hearing where we'll hear testimony from the public, rebuttal testimony, closing the public hearing. We'll have a discussion amongst the commissioners and then decision. So at this point, we are ready to hear from the applicant.
Good evening, Commissioner, staff. We had not prepared a presentation for this evening. We have no objections to the staff recommendations and report, as well as their anticipated draft decision that we received. So if there are any questions, I will stand for questions at the minute.
Thank you very much. Any questions for the applicant?
Questions?
No questions here. Thank you.
Thank you.
We will open it up to staff.
Chairman, Commissioners, good evening. Just everything is already in the staff report, but just to discuss, set the stage a little bit of what this application is. Chairman Montoya already introduced the file number and location. This application is for the boardwalk apartments that are existing and recently approved. They're part of an overall site design that is currently open and consists of two other structures. And so typically in a conditional use permit, there's quite a bit of attention to, are there any deficiencies, physical deficiencies on site? In that this is an open approved application, staff did not delve into a review of landscaping, et cetera, in that the approved application is what governs in this instance. And the specific request of this application is that the applicant had indicated that they really feel like their site, their structure is acting as a unit. So in the commercial spaces, there may be retail or an eating establishment or a drinking establishment, and there's some fluidity to that. And so instead of coming back time and time again, every time they have an additional tenant, they requested if the city could look at their site very similar to how the city has the industrial flex use set up. They're not asking for industrial flex, but similar to how that operates, where an applicant can come in for kind of a blanket allowance for different uses under one conditional use that allows for the tenants to move in a little bit easier, instead of having to go through this process repetitively. The staff has suggested that uses that would be appropriate are accessory uses, artist studio, that otherwise require conditional use permit, bicycle sale, service and storage and rental, drinking establishment, limited services, eating establishment, full service, eating establishment, limited service, financial institution, food store, health club, laundromat, mobile service, personal service, professional service, retail production, retail store, self-service uses, temporary use, and tobacco retail store. And that really is the gist of my very quick presentation. I'm happy to answer any questions.
Thank you, Ms. Thornborough.
Thank you.
So if I understand it correctly, in this situation, effectively, what the way that staff is looking at it and the explanation is that there's an overlay that's basically been approved for the development that has certain conditions like landscaping, setbacks, parking, bicycle parking. And so that's been approved for the development itself. And so with this type of application and these types of uses, parking, for example, there wouldn't be any type of deficiency that you would identify in that type of situation that would cause concern for just a CUP, a conditional use approval for that use.
Chairman, thank you very much for bringing up that great point. So the way that this is conditioned is that it's not looking at changes to the physical changes at this point in time. It's just looking at use themselves going into tenant locations. The one thing that staff had noted in the staff report is parking is a really hard thing to try to establish. And so it's noted that if it becomes in the staff report and in the decision document, if parking becomes a nuisance, that the city could revoke this, because there's no way to anticipate all of the iterations of the potential uses that you could have and effectively review the parking standards. I also did want to note that this does not preclude any building permits or any design review permits that would be triggered otherwise.
And just for the sake of clarification, if there was a permitted use, for example, there would not be any review. So it'd effectively be just saying that the condition is permitted, just like a number of other items that are permitted within that section.
Chairman, that is correct. That is how city code is set up. If there's a permitted use, that will not come through this body. And so effectively, it's almost like making these permitted uses.
Thank you very much. Any other questions?
Thank you.
All right, hearing none. Thank you very much. At this point, we'll open up the public hearing. I know that we do have some sign-up sheets. Was there any other sign-up sheets for this item? Oh, all right. All right, we have 3 members of the public that are here to testify on this item. First is Tiffany Hicks. Tiffany, if you wouldn't mind stating your name and address for the record, and you will have the floor.
Great. Good evening. My name is Tiffany Hicks, and my address for the record is 749 East Park Boulevard, apartment 119, Boise, Idaho, 83712. Thank you for having me. My name is Tiffany Hicks, and I'm a former resident of Boardwalk Apartments, to speak in opposition of granting additional permits to Crispy Investments LLC and their managing partner, Michael Talbot. For context, Boardwalk Apartments, located at 521 East 41st Street, was developed and is owned by Vita Properties, also led by managing partner Michael Talbot, who's based in Boise but originates from Orange County, California. I want to be very clear. This is not based on opinion or assumption. This is based on my direct experience and documented steps I had had to take to resolve serious issues during my tenancy. During my lease, Boardwalk and their management company, Vita Properties, engaged in practices that I believe were not only unethical, but in breach of their own lease agreement. One of the most significant issues was their handling of rent increases and notice requirements. One of the most, my lease required that they provide 90 days written notice for any rent increase. My lease was set to end April 3rd, 2025, which means notice should have been provided no later than the first week of January.
I have a quick question. So are you a residential tenant or are you?
I was a residential tenant. I apologize. I should
And
have
so
clarified
do you
that.
have testimony concerning the uses or the conditional use permit for the application
I'm
outside?
opposing, and I'm kind of explaining why I'm opposing it.
Okay, I
So-
just wanted to make sure that it wasn't just in regards to a dispute that you're having on the lease itself of the residents, but to the actual conditional use permit that we're talking about tonight. So, okay, go ahead.
Thank you. I'm just kind of building up to it. I apologize. My lease required they provide a 90 days written notice. My lease was set to end April 3rd of last year, which means I should have received that notice at the beginning of January. Instead, I didn't receive it until mid to late January. Despite failing to meet their own contractual requirement, they still attempted to hold me strictly to a 60-day notice requirement to vacate. So while they expect full compliance from me as a tenant, they did not follow the same contractual obligations themselves. That is not just poor business practice, it's clear breach of contract. It also reflects a lack of integrity in how they apply their own agreements. They enforce terms when it benefits them and disregards the same terms when it does not. In addition, I was charged monthly common area utility fees that came with no itemization, no usage breakdown, no transparency. When I requested documentation to understand what I was being billed for, nothing was provided. Even more concerning, there were consecutive months where the charges were exactly the same amount to the cent. That raises serious question as to whether these were truly usage-based fees or simply flat charges being presented as variable costs. Those fees averaged over 50 per month on top of my rent for a single tenant. To put that into perspective, my personal power bill through Idaho Power, even in high usage months, was around 80. So I was being charged more than half my personal utility costs just for common areas without any proof of breakdown. At my current downtown Boise residence, common area utilities are billed directly through a utility provider with full transparency and itemization. At Boardwalk, those charges were simply added to the resident portal ledger with no explanation. A lack of transparency in billing is not just frustrating, it's a failure of accountability. Then there were the rent increases themselves. I'm not going to go into that so much, unless you have questions. But I want to go into the fact that what is most concerning is how the issues were handled. I raised concerns directly and repeatedly during my tenancy. Nothing was addressed. It wasn't until I filed formal complaints with Idaho Attorney General's office and the Better Business Bureau and began sharing my experience publicly that I received any response. When I spoke out, I was contacted by numerous current and former residents who shared their identical experiences, patterns of poor communication, lack of transparencies, and practices that felt predatory. This is not an isolated situation, it's a pattern. Then after I completed my final walkthrough and turned my keys, and within less than an hour, I received a call from their general manager who works directly with Michael Talbot, asking to meet me in person to hear my story. At that point, the same issues that had gone unaddressed for weeks were suddenly urgent. They ultimately agreed to my terms, but only after I made it clear there would be no negotiation because they were the party in breach. During that conversation, I was asked to stop what they referred to as a smear campaign. Sharing factual experiences is not a smear campaign, it's accountability. And accountability should not require escalation, public pressure, or outside intervention. It should be part of how a company operates from the start. I also want to address concerns around how this company manages its public reputation. If you look at their own online reviews, there is a noticeable pattern. Approximately 9 months ago, there was a significant uptick in positive reviews. This occurred shortly after a wave of negative reviews from residents and others sharing their experiences. At the same time, many of the positive reviews appear to come from individuals connected to the business. Meanwhile, negative reviews are often challenged or dismissed with responses stating they have no record of the individual ever living there or touring the property. That response ignores the reality that reviews can come from more than just tenants. Guests, visitors, and patrons of the commercial spaces also interact with the property. There have been multiple instances of guest vehicles and restaurant patrons being towed, which leads to negative experiences and public feedback. In addition, I was personally asked to remove my own negative review. It's not how a reputable business operates. Transparency and accountability should not be managed by attempting to suppress or counterbalance feedback. I also want to raise an additional concern that should not be overlooked. The operator is currently involved in litigation with past commercial tenants. That alone should give this body pause. When a company is actively being sued over its business practice, it raises serious questions about how it operates across the board. At a minimum, it would be reasonable to delay granting any additional permits until those legal matters are fully resolved. Approving expansion while those issues are still pending I lost my place. I apologize. At a minimum, it would be reasonable to delay granting any additional permits until the legal matters are fully resolved. Approving expansion while those issues are still pending sends the wrong message about accountability. So I ask you to consider this. What kind of operator only responds when pressured publicly? What kind of business enforces lease terms on tenants but does not follow them themselves? I keep losing it, sorry. What kind of company lacks transparency in how they charge residents? And ultimately, what does that say about their integrity? And perhaps most importantly, why is it happening here? This ownership group originates from Orange County, California, where tenant protections are significantly stronger. It is reasonable to question whether these same practices would be tolerated in that environment. Because based on my experience, it appears they are taking advantage of the gaps in tenant protections here in Idaho. Development should add value to the community, not exploit it. From my experience and from many others who have shared similar stories, I do not believe the boardwalk has demonstrated the level of integrity or accountability necessary to justify further expansion in this community. I urge you to look beyond the proposal in front of you and carefully consider the track record of the operator behind it. Thank you.
Thank you.
Question.
We actually have a question here from Commissioner Brown. Commissioner Brown, is this for Ms. Hicks?
Pardon?
Is this a question for Ms. Hicks?
Yes.
Okay.
Thank you, Mr. Chairman. So I understand. So you have a dispute with the applicant. Have you managed to acquire any kind of judicial judgment or injunctive relief that would preclude them for proceeding with their business?
I don't have a current dispute with them. This was last year.
Okay.
Yeah, that was all resolved with me and the partner, like with the managing partner, his general manager.
Thank you. Thank you, Mr. Chairman.
All right, thank you.
Thank you.
The next that we have signed up to testify is Chris Herbert. Please, for the record, state your name and address, and then I'll ask this question as well. Is this regarding a dispute that you're having with the the property owner, or is it about the conditional use permit and the actual use that we're discussing today?
It is for the conditional use.
Okay.
And what's being discussed today.
Thanks, sir.
My name is Christopher Herbert. I live at 404 East 40th Street, Garden City. Commissioners and staff, thank you. I am in opposition of this approval of this conditional use. My brother and I having attended the meeting and received this very long list of all of the uses that they want blanket approval for, some of which are not even conditional but prohibited in the zoning for the building. It's really just asking for blanket approval to do whatever they want in that space, and I don't think that's very fair in terms of the zoning. What the uses are supposed to be, what a conditional use stands for. I think that a conditional use is a very specific use that needs to be thought out. I know you all have specific criteria and what you have to look at for those uses, and just basically providing blanket approval for every listed use that they provided is not fair for other people and their zoning, other developments, for the place itself. I live right next to the development. I will say that parking is and has been since the beginning of this development an issue. It has been contentious and it's lacking. And blanket approval for, you know, anything from daycare facilities to storage facilities and wrecking yards seems pretty absurd to me. I would like to think that the city would, you know, take a uniformed approach in how they approach conditional uses and how they're applied. Thank you.
Thank you very much, sir. Appreciate it.
Yeah.
Thank you. All right, we have one other member of the public here to testify, Frank Jordan. And again, state your name and address for the record, please.
My name is Frank Jordan. I'm the chef owner of Bowboy, previous tenant of the boardwalk. My address is 1308 Tetonia Drive, Boise, Idaho, 83705. And I just want to stand up and oppose any special privileges to Mike Talbot, but I can't further comment due to the pending civil suit that we have against each other. But I just want to stand up and oppose any special conditions or any privileges for Mike Talbot at this time. Thank you.
Thank you, sir. Just to make sure, staff, there's no one else signed up to testify. Just making sure that there's nothing else over there. All right, thank you. With that, we will turn it back over to Ms. McNeil for any rebuttal testimony. The applicant. Would you like to provide any rebuttal testimony?
Oh, yes, absolutely.
Oh, I'm sorry. Yep, I said the wrong name.
No worries, no worries. I just wanted to address Mr. Herbert's testimony. You showed up to the neighborhood meeting and we had the conversation about not really all of the uses we feel are appropriate. And so with further coordination with staff, that list has actually been reduced quite a bit. And most of those uses, I believe, again, may or may not happen. It's just to provide flexibility for the owner in the future. So I would recommend that you look at the current uses that are being proposed here at this moment for the CUP. And then if you have any additional questions on those, maybe we can give you some further insight on that.
Thank you, Ms. Miller. And
Thank
again,
you.
apologies for the incorrect name.
No worries, thank you.
Before you leave,
Yes.
any other questions for the applicant?
I had no.
All right, thank you very much.
Thank you.
Any other questions for staff or before we close the public hearing?
I don't think so.
All right, at this time, we will close the public hearing. This matter is now before the commission. We are a decision-making body for the CUP. So we can hear from fellow commissioners. Commissioner Smith?
Thank you, Mr. Chair. In looking at the revised list, I don't have any specific concerns, especially as conditioned by staff. I understand the intent, and I think that it makes sense, given in this particular case that the overall structure is already established, parking is fairly established. The need to uniquely condition each use, I don't think is necessarily here. And I think staff has done a really good job working with the applicant to whittle down and identify where some of the pain points are and make sure those are either not included in the list anymore or properly conditioned in a general way if they ever come to fruition. I'm certainly interested to hear what the rest of the commission has to say, but overall, I don't have any overarching concerns.
Thank you very much. Commissioner Brown?
Okay, Commissioners, Mr. Chairman. I'm in favor of approving this and would be prepared to recommend that, or not recommending. We are the approving body. With regard to the two people, one that apparently had a dispute and one that does, we're not the proper body to settle that, and would only get involved with it if there was some kind of injunctive relief or a judgment that had been made, in my understanding of the situation. With regard to the other gentleman, I think it is adequately justified in here and specifically identified in the way it's written that if they did any of these uses that violated any of the specific criteria for each specific use, we have other regulations that would preclude them from doing that. And it's further limited by specifically saying that this would, any uses that are by this development agreement for this that we've has already been approved, anything that violated that would not be permitted to be on the site. And that's one of the prime conditions that's in that. So given that, as I said, I would be prepared to approve it.
Thank you, Commissioner Brown. Commissioner Shepard?
Thank you, Mr. Chair. When I look at this blanket allowance in place for the approved types of businesses, I am also in agreement with approving the cup. I think it would bring ease to future tenants, and while I can have some level of understanding for the past tenants and their situations, I also agree that it's not in our, like, we're not the proper body to bring those forward right now. And I think that this just could be easier in the future for people, not each business not having to come in and get its own CUP. And with the development agreement in place and the ability to look at parking concerns in the future, I think I would be in favor of approving it.
Thank you, Commissioner Shepard. I as well echo the fellow commissioners. I would have a concern if the approval was for certain things like wrecking yard storage, but as the applicant and staff has acknowledged that there is a list that's been modified in order to meet what would typically be the use in that type of structure. And so I haven't seen anything at least proposed that would cause me concern in that. Some of the questions that I had earlier were simply just to acknowledge the fact that there are other plans in place and other documents that have been approved prior to this CUP that do provide regulation. So I'm in favor of the applicant and recommending the application, or actually recommending for approval of the application. And at this point, is there any further discussion amongst the commissioners? All right, hearing none, I will entertain a vote, or I'm sorry, a motion.
Mr. Chairman,
Commissioner Brown?
I move approval of CUP FY 2026 number 9, a conditional use permit for Julie Miller with Studio H Architects, including in the draft memorandum of decision, include that staff recommending the findings of fact, conclusions of law, and conditions of approval.
Thank you, Commissioner Brown. Do I have a second?
Second.
Have a second. Any further discussion on this item? Hearing none, we'll take it to vote. All those in favor say aye.
Aye.
Any noes? The ayes have it. Right. Next item on the agenda is CPA FY 2026-001. This is a code text amendment. Jeff Hatch with Hatch Design Architecture is requesting to amend Title 8, Chapter 2B, Section 1, Table of Allowed Uses in all base zoning districts. So again, with this, we will have a brief introduction by the applicant, staff reports, public hearing, rebuttal testimony from the applicant. We'll close the public hearing. And then we'll have our decision. So Mr. Hatch, Mr. Main. All right.
Thank you, Mr. Chairman, Commissioners. For the record, Abby Germain with Elam and Burke, 251 East Front Street, Boise, Idaho, 83701. Hannah, how do I get that? Thank you. Great. Thank you. Apologies, Mr. Chairman, Commissioners. As mentioned, we are here this evening requesting a code text amendment. Also here with me this evening is Jeff Hatch with Hatch Design Architecture. He's here to answer any technical questions the commission may have. Before I get started, I think it is important to just give a little background on this proposal and the project that led us to seeking this code amendment in the first place. I think some of you on this commission may remember we were here in front of this commission a couple years ago seeking approval of a planned unit development for this same project. The project looked much different at that point, but it was the same proposed use. And at that time, in the discussions with the commission, staff, and ultimately city council, we received direction that a code amendment would be a more appropriate avenue to pursue this project. So that's why we're back in front of you this evening. We are requesting as part of the amendment that the C2 zone, the mixed use commercial zone, be amended in its table of allowable uses to include Class A storage. So just as way of background, when we think of storage facilities, I don't know if you think of it like I do, but I think of the single level kind of blighted, under-designed storage facilities. And that in the industry is commonly referred to as Class C. That is not what we're requesting. We're requesting that the commission consider allowing only Class A storage facilities within the C2 zone. And just to provide an example, when we're thinking of Class A, we're thinking of something that's highly designed. It includes amenities that include climate control, state-of-the-art security, multi-dimensional units. So it's not what you typically think of when you think of storage. I bring this up. I know we are specifically talking about only the code amendments this evening, not the conditional use permit or the design review approval that would be needed for this project. But we are talking about it in the context of a project for our purposes, and that's why we're bringing you the code amendment. So this is the project that we would be requesting approval for at a future date. But turning back to our specific request, in order to allow Class A within the C2 zone, it would require an amendment to the table of allowable uses, which would allow, again, only Class A, and it would also require that a conditional use permit be approved in the class 2 zone for class A storage. Excuse me, the C2 zone for class A storage. So another protection on this proposed code amendment for this commission and for staff is that it would not be a blanket approval for any class A facility to come in. You would still need to apply for a conditional use permit, and the individual project would be looked at on a case-by-case basis. In order to facilitate allowance of Class A within the C2 zone, it would also require a new subsection in Title 8, Chapter 2C, which would establish specific standards and requirements for Class A. So again, what we want to prevent is Class C or other types of facilities coming in to the C2 zone. We want to ensure that if the commission decides to move forward with allowing this type of facility, it really looks like the type of facility that we're proposing and that we hope would be accompanying a Class A application. That will also include adding a definition for Class A within Chapter 7A of the code. And then finally, it will require an addition of Class A self-storage within the parking requirements that are found in Chapter 4D. So that is the specific text amendment that would be required to allow this change in the code. In discussing this application with staff and the design review consultants, it became clear that there were some, I would say, more project-specific feedback and then generally the code amendment related feedback. And in your packet, I believe you have 2 staff reports from staff. One that's a little bit longer in length and covers the full response that we received from the design review consultants. And then you also have what I would call the supplemental report, which is a shorter 3-page report that was provided by staff after the design review consultant meeting and after we had a chance to respond to some of those issues. So what you'll see in that first staff report is that there are numerous comments and feedback related to the proposed text amendment and also some project-specific items. We, in turn and in response to that, provided a revised version of the proposed code amendment addressing some of those concerns and issues of staff and the design review consultants. And you'll see in that supplemental report, there's a table or a box that staff has provided that shows the issues that we have resolved and then issues that they believe are still outstanding. And so what I want to focus on are those issues that staff and the design consultants believe are still out for discussion and potential resolution. The first item is what I'm referring to as the ground floor activation of this project. And again, on a broader context, as it relates to the code amendment and the city-wide implications, I believe the concern or the request from staff and design review is that a project like this, if it were to be allowed within the C2 zone, should not include storage units on the street-facing facades. So in other words, there should be more pedestrian engagement and ground floor activation that you don't really typically necessarily see from a standard storage unit. We have heard that. We went back to the development team and the ownership on this project. We discussed this request from staff, and we came back with an amendment, again, to our specific project that would include revising this so that you do not have storage on, and I don't know if you can see this cursor, but you would not have storage on the street facing facade. That would instead be an office for the actual facility, so a leasing office. And then you would have additional retail office space and artesian potential in the rest of those spaces. So you've removed the storage units from that side, and you've included something that really responds to staff's concern about street floor or ground floor activation. And again, applying this to the larger code amendment context, we believe that it would be appropriate to have this type of requirement. So in other words, stating that the ground floor on street-facing facades could not include storage units for any future projects that were proposed in the C2 area. So we believe we've addressed that issue. The next two items that were brought up by staff in design review were what I'm referring to as the 1 mile exclusion and the zoning district discussion. Both of these items were included in our code amendment in response to what we heard from staff as a potential concern of having a lot of storage facilities, an influx of storage facilities within the zone or within the city, frankly. And so our response to that was to include a 1 mile buffer that no additional Class A storage facilities could be built within 1 mile of an existing Class A facility. What that would, in theory, do would be to incentivize, again, the intent of this zone, which is mixed use. So you would not have a cluster of storage facilities in this area. And instead you would be dispersing those, and they would be located in a place where the need is really relevant. One of the reasons, and this is just aside on this project, that the development team and the ownership decided to pursue this type of use within this area was when they began looking at what would be appropriate, they gave credence to what they had heard about concerns with traffic, city services. And what was decided was that something like this, where you have a high-end, high aesthetic design facility, provides an amenity that's needed, but does not really increase traffic and does not put a strain and tax on city services, so EMS and sheriff. That is obviously much different if you look at a different use, like residential, multifamily residential, for example, restaurants, et cetera. So when we were weighing options of what to put in this area, it seemed that based on the influx of multifamily that we've seen in this area, this is a commodity that we're seeing is needed, but also doesn't tax city services and add to traffic concerns. So that those same aspects are why we were including some of these limiting restrictions related to the 1 mile exclusion and then other zoning districts. Related to the other zoning districts, we had proposed it in C2 only. My client is happy to revise that based on commission feedback. If the commission feels like Class A should be allowed in other zones, we're happy to do that. Again, the reason for including it only in C2 was an effort to try and limit where we have these facilities and how many of them we have in the city. So certainly would look for guidance from the commission on that. Staff and design review also raised the issue of Garden City Code 82B4, which states that if you have a development on a site that's 120,000 gross square feet or more, at least 10% of that square footage needs to be dedicated to dwellings, or the development needs to be allowed by a conditional use permit or planned unit development. We understand that. We will be applying for a conditional use permit for this project, and we would expect that other projects would have to do the same. So if their site exceeded that number, it would be an expectation and in the code that they would have to either apply for and receive a PUD or a CUP. The next couple comments are related. There was a comment by design review and staff about, well, how do we deal with this type of project in an activity node, specifically a neighborhood commercial node, or in future land use designated areas that don't anticipate storage in that area. Again, I think there's two responses to that. First, it's not all storage that we're saying the code should be amended to. It's Class A only. So I think there are aspects that would deal with future use designations and concerns about what we're incentivizing or allowing to be in certain zones. And then again, taking it more specific to the lens that we're looking at this through from our perspective with our project, we are not included in an activity node. So none of those restrictions would be applicable to us. We would have to request to be included in an activity node. So from our perspective, I don't think there's an objection to some kind of limitation in the code amendment saying that you know, if there is an activity node or if there is a future land use designation that would prohibit this in the future, you know, this isn't going to be an exception for that. You would still have to, either it wouldn't be allowed or you would maybe have to seek a PUD or a CUP for it. And then lastly, there were comments by staff and design review related to the adaptive reuse and the structural flexibility of this project. In other words, looking at how could this be built in such a way that it would allow future or different uses that aren't storage, if that were to be an option in the future. In discussing it with the development team, we have made revisions to our specific project that would minimize interior load-bearing walls. And the nature of storage facilities in and of themselves are such that there's not a lot of plumbing or electrical or other systems. So they're pretty easy to revamp and change. You know, you can take down interior walls and revamp the building to suit something else in the future. So to concerns as they relate specific to our project, we have and will address those. And are happy to have any kind of text amendment within the code that would reflect this should be a requirement and a standard for future projects within the city. This is just a depiction of the specific location we're talking about. So this facility would face 42nd Street. And again, the ground floor changes that we've made to our specific project would eliminate storage units and facilities on that side. It would include office space and retail options. And yep, these are just additional renderings of the project. So again, understanding we're here in front of you for a code amendment, not a conditional use permit or design review at this time. Understanding we'll be back in front of you to request that. But happy to answer any question the commission may have. And we are requesting a recommendation of approval to City Council for this code amendment.
Thank you, Mr. Main. Ms. Thornborough.
Chairman, point of clarification for the commission. I know that Ms. Germain was careful to say that the application tonight is not the site-specific conditional use permit application, but we did see some images. So I really do want to put it out on the record that staff does request that we stay to the code to the extent possible, both for deliberations as well as any public testimony that we see in any rebuttal as well. Thank you.
Understood.
Thank you very much. Any questions for the applicant? Commissioner Brown?
Mr. Chairman, I have some specific questions. However, before I ask them, they may be answered by the staff. So what I would like to just make it a point that I want to save my questions for the rebuttal portion and to give the staff an opportunity to respond. And I would request kind of especially address her memo in which she responded to the response that they made to the design review consultant and to the staff, and with specifically addressing those items that in her memo, at the time of her memo, had not been addressed in her opinion.
Thank you, Commissioner Brown. Any other questions for the applicant? Smith?
No, thank you.
Thank you very much. We'll now hear from staff.
Good evening, Chairman Montoya and members of the commission. I'll be presenting the staff analysis on this code text amendment known as CPAFY 2026-0001. It is for a storage facility, self-service, Class A use. within a C2 zoning district. I was going to go into the fact that this is only the code text amendment, but I think we've beat that to a pulp. So please, let's just keep it to the code text amendment and not the pending conditional use permit or design review. My presentation is going to focus on that proposed code analysis that you've seen in the staff report, as well as the secondary staff analysis, which went out really quickly last Friday. I called it the staff memo. Both go into detail as to whether or not the proposed code text from the applicant is ready to become a permanent rule, a quote unquote rule, found within our Title VIII development code. So staff's role in this hearing is it's a little bit more narrowed down and it's a little bit more specific. So we're analyzing the text, and in doing so, and with your help here tonight, we need to make sure that it meets the 3 legal standards required for adoption. So the first one is being that, does the code text language comply with the comprehensive plan? Number 2 is, does the amendment materially detrimental to the public health, safety, and welfare? And number 3, does it adversely affect the public service delivery? The core question tonight is not whether the Class A storage use is a good product or a good business. It might as well be for Garden City, but the question is whether or not the proposed text is ready to become that citywide rule. So that's going to be our mindset tonight. Staff has identified issues in the current proposal that prevents these 3 findings, and I'll go into that a little bit later. And that was also identified in the staff report, but I'll walk it through now. Walk through it now. So before we get into those specific issues, I wanted to ground everything in that legal standard. So this slide shows those 3 findings that I already discussed. And that is what City Council will be considering when they, as the ultimate deciding body, will be making the approval or denial or any other recommendations based off of this application. It is your job tonight, as the recommending body to City Council, to decide on these matters. So finding number 1 is the comprehensive plan compliance. So this is a big one for this application. The C2 zoning or C2 zone overlaps with a lot of different future land use designations of the comprehensive plan. And all of those designations, they don't all have the same goals. It ranges from more heavy commercial industrial to really low density residential districts, and as well as mixed use. We don't typically see C2 zoning within the lower density residential designations of the comprehensive plan, but there's 2 different maps, as you will, that need to be considered when talking about the code tonight and making your decisions. So finding number 2, not materially detrimental. This is where the enforceability issues live. So any kind of vague standards within the code, such as the, I'll say previous ground floor activation gaps, would be or could be combated is not the right word, but could be in conflict. And like a code enforcement case could not occur, and it would be difficult for future deciding bodies to make a decision on a future application. And finding number 3, there is no adverse service impact. This one seems to be met. Staff doesn't have any concerns about the public services being affected by this use type. I think as if this were to get adopted, this is a common finding found in the conditional use permit application, so it might be more applicable to that specific future property and use. But as a general whole application, staff wasn't able to find an adverse impact. And then I just wanted to quickly go over the process record of this application. It has been fairly quick, and I wanted to call that to your attention. So the application was submitted in January, sorry, there's a typo there, January 26th. And accepted by staff as a complete application on March 2nd, with the neighborhood meeting being held March 11th. Staff then issued the first report on March 30th for the design review consultation on April 6th, identifying the 14 issues as discussed in the staff report. And then the design review consultation was held on April 6th, which raised those code concerns about the ground floor use and design, the pedestrian activation, and the structural adaptability. And then on April 8th, just about a week ago, the applicant was able to submit those revisions to it, in which case staff gave that secondary memo on April 10th, which was Friday. Staff has not been able to look at the new material as presented tonight. So that's obviously not included in the staff report or anything of what I'm saying. But I did want to make it completely transparent that it does seem like some of the comments and concerns of my report have been addressed, as well as the design reviews. I just have not been able to look at that and update the decision document or the staff report. As I said earlier, you guys are the recommending body, and the city council makes the final decision on this application, which is scheduled for May 11th at this point. You have three paths here tonight. You can either recommend denial, you can either recommend, or you can recommend approval with the conditions as drafted. The drafted decision document had I don't know how many off the top of my head, but had some conditions drafted, and then the staff memo needed to add a few more based off of what the design review consultant said. So those are all on the record. Or you can continue the hearing to a later date, whether it's May, June, July, it's up to your discretion. And then request that the application go back to the design review consultants in order to resolve whatever pending comments there might be, as well as working with staff to get a fully hashed out code in front of you at a later date. So this is the scorecard, the issue scorecard. It's a roadmap for what I'm about to cover. I'm not going to go into super deep depth unless you guys have any questions, but these are the 14 issues. 7 have since been resolved. 1 is partially been resolved, and then 6 have been unresolved. The green rows are considered resolved. The applicant either addressed these directly in that first revision, in that first revision. And then the amber row, which is the ground floor activation, has been partially fixed. And then the red rows are the issues that the applicant had either declined at the time to address or they hadn't acknowledged it at all. So again, these are not including tonight's comments in the presentation. What did the applicant get right? And I want to be fair here. There are a lot of things about the application that staff thinks is genuinely good. It has good bones, and that they got correct. And so I don't want it to get lost in the deficiency conversation. But requiring a conditional use permit That is a good structural call. It means that you as the commission will be able to evaluate every individual project before it gets constructed or gets a certificate of occupancy, at least at this point in the C2 zone. So that is appropriate. The urban design ambition is real. The multi-story, the glazed street frontage, the architectural standards, that's all a very good instinct for the type of Class A storage use that the city is likely wanting to see. The question is whether or not the code language as drafted actually gets us there and delivers that product. And then identifying the code gap is legitimate. So there is no current Class A storage facility use. However, there is a self-storage use. So the question is, does a Class A use, is that appropriate in and of itself, or does it need to be further hashed out into other types of classes? And if it doesn't, how does a existing self-service storage use compare itself to a Class A? Or is there any kind of gap there? So as I said, it's all good work, but I think it just does need to be hashed out a little bit more. And then getting into the meat of it, so we've got the code structure and the asterisk issue as mentioned. So previously the applicant had proposed the new use to be under 8.2C as a new item, which would have been 50. Staff suggested that it just get moved up to the rest of the storage uses in that 8.2C 37 section as item J. The applicant had complied with that. And then there's the issue of the definition. There's a new definition. It calls for an enclosed climate controlled structure. Then the security language. So it had previously just been too vague. Now it's been enhanced a little bit more to be more of that monitored electronic access control internal camera system. The outdoor lighting has been moved, or it just is requiring our typical standard Garden City 8.4A code. Parking standards have been added. Previously, it wasn't in the parking table for either vehicles or bicycles, so that's been added. And then the pedestrian amenities, etc., was vague text. And so as staff recommended, the cross-reference to 8.4C non-residential structure standards has been added to address that gap. So what a good code amendment drafting would look like. Here on the left, we have the original drafted version, like the 8.2C50 as a new use. And then based off of staff's recommendations, they bumped it to the 8.2C37 Class A standards. So this slide is essentially just meant to show the difference between a standard that you can enforce and a standard that is harder to enforce. And enforceable means that any future permit reviewer, such as staff or decider like the commission, or maybe even a future code enforcement case, would be able to go back to this code standard and make it a yes/no determination instead of leaving it up to interpretation or like a judgment call. So what has been left unresolved is the ground floor activation. It is still the most significant issue that remains. So the applicant made a fix here, referring it to the H4C commercial zoning code as for the design. So the design is leaning on the existing 8.4C code for commercial buildings. However, at the design review consultation, the consultants had requested that it's not just the design that is ground floor activated, but they actually wanted uses that helped to enhance that ground floor activation. So they went as far as saying that it needed to be non-storage uses. So like a leasing office, a lobby, retail, or similar. And then, so this provision is a little bit different regarding the 1 mile exclusion. The other issues are more of like drafting issues, whereas this 1 mile exclusion issue is more of a policy issue. And I'm presenting it to you tonight more to have that discussion or open that discussion. Because I guess I'll preface this with the existing code does not have any kind of distance requirements for storage facilities. However, there are uses within the code, the existing code, in which distances are required between either uses. For example, drinking establishments like a liquor store or a bar would need to be 500 feet away from a school. There are also drive-through establishment regulations where drive-through roadways or curb cuts would have to be 500 feet away from another drive-through establishment curb cut. And so this type of provision where it's a 1 mile exclusion, especially considering it's within Garden City, and Garden City is fairly narrow and small, it just could be cause for concern. And is a 1 mile exclusion appropriate, or does it need to be smaller? Or does it need to be more use oriented, or future land use designation oriented? And I could go into the remaining unresolved issues, but some of those have been discussed tonight by the applicant. So I don't really want to dive too deep into them. For example, the mix of use conflict. The applicant has addressed that as of tonight. It does not need to be within the 8.2C code that they're proposing. I did want to make a point of clarification though regarding the neighborhood commercial overlay. So we have 2 different codes, and they all kind of sound the same. So it's very easy to get mixed up. In the comprehensive plan, we have a neighborhood destination node, also known as an activity node. And that is identified as the intersection of Adams and 42nd Street. And there's a lot of other locations within that node, other intersections, I guess I would say. And I know we don't want to get into application specific like conditional use permits, but it was brought up in that case. And I just want to clarify that it is within that activity node. And that is a good way to understand whether or not the use is appropriate in that location. Then the other overlay is an actual code overlay, and that is the neighborhood commercial node, which is in code, and that is something that the applicant can choose to be within and regulated by. And so within that node and that overlay, there is a separate chart of allowed uses, prohibited uses, and conditional uses, and that has identified the self-service storage use as completely prohibited within that node. So in the staff report, when it talks about the neighborhood commercial node and storage uses not being allowed at all, it's more of a good guidance across the city as a whole as to whether or not this type of use would be appropriate in that node. So it's already kind of been hashed out in that regard. And then getting further into discussion of where this type of use would be compatible. This list is a list of the future land use designations. We have from mixed use to light industrial, Green Boulevard corridor, those activity nodes, the live, work, create district. All of these designations have a C2 zoning district in them. So a use like a self-service Class A storage facility might be applicable or appropriate in something like the light industrial Bradley designation, whereas it might not be appropriate in the live, work, create district. So in the staff report, this got into a lot more detail and depth, and I can answer any questions about that. But that's also just something to consider when thinking about where this use is appropriate. And then to finish it off, I'll repeat myself, but you do have 3 options here tonight. Staff does recommend that the commission postpone the public hearing to a later date and does send it back to the design review consultants to get some of those design oriented conditions and standards hashed out. That way they can come to you with a more straightforward code that you can read, and we don't have all these conditions like drafted in the condition document. And with that, I'll stand for any questions.
Thank you very much, Ms. Beal. Any questions for staff?
I don't have any questions. I think she answered mine for her.
Commissioner Smith?
I have one quick question. On the storage facility, I know you mentioned that in the code, we have storage facility self-service, but above that, we just have storage facility. So why doesn't Class A, I mean, I know it's a really fancy storage facility, but why doesn't that just fall under the definition of storage facility, not self-serve?
So as it stands, this type of facility would just categorize itself as a self-service storage facility.
Okay, I'm just thinking about the gap in the code discussion. So if we were to put it in a category now, we put it in storage facility self-service, not the one above storage facility or yard.
Correct.
So it's still self-service. It's just
yes,
nice self-service.
Yeah, so it's still, the way I envision it is it's like another subsection of that self-service use.
And what makes it a subsection?
I believe it's just the Class A. And so that, I mean, that is where it has been confusing to try and figure out how someone can come to the city and say, I'm only a self-service use versus the Class A. And then we also have someone saying that I want to be Class A. So it's almost like we have 2 uses that are the same, but then only one can like kind of pick to go to the Class A route.
And what makes it Class A is essentially just its niceness. I mean, really, as far as its attractiveness and
yes,
is that is that really what we're talking about?
I believe so. I mean, the applicant can also
I'm just thinking by that
decide that, but
definition, I
yeah.
mean, could you take anything in the light industrial and say, you know, we have a class A version, so like vehicle sales, that's also only allowed in C1 and L1. So we could say, well, I'm a class A vehicle sales. I have really beautiful building and, you know, I park the cars in a really pretty way and make a mural out of them or whatever. So I'm kind of a fancier version. So I guess I'm just trying to figure out how we would, if we're going to sort of break down a category, couldn't that logic apply to any category where you kind of break it into better and worse versions of the same category? Does that make sense?
Yeah, yeah. Yes. I mean, you have to be careful as to like how detailed you actually want to get. We also have a provision within the existing code where it's if that use doesn't seem to be the most, like we're trying to pigeonhole a use or function or business into some use that already exists, that person or business can go through the cut route already.
To say, I don't really fit in this category,
Yeah.
I'm different.
Yeah,
Okay,
so,
gotcha.
yeah.
Okay. But in this particular case, without a code amendment, they didn't really have the CUP option because if they're in that category, they're just not allowed in the zone. And you can't use the CUP to get around that.
Yes.
Okay, thank you.
Yeah.
Any other questions? Commissioner Brown?
No, I don't have any questions for her.
Okay. Thank you very much. I appreciate it. So at this point, we will open the floor to public testimony. A couple reminders that we've heard from staff as well is please keep the testimony to the actual application at hand, which is the code amendment, not any type of storage facility that is being requested under some other application. We do have a couple of written testimony that has not indicated a wish to testify. One, Alexander, opposes the application and does not wish to testify. And we have John, who opposes the application and does not wish to testify, and these will be added to the record and provided to staff. We have Dieter, who opposes the application and does not wish to testify. That leaves two members of the public who have signed up to testify. The first, we'll turn it over to Brad. And Brad, again, when you approach the podium, please state your name and address for the record, please.
Good evening. My name is Brad McGurr. I'm here with my wife Julie. We live at 4213 North Hardtail Lane, Garden City, 83714. Hardtail Lane, if you're not familiar with it, is the Parkway Station development right off of 42nd Street. So we're well aware of this issue, not just tonight, but in prior attempts to have this storage facility built. First of all, let me just say thank you for your public service. I know only too well it's oftentimes a thankless job. So thanks for dealing with all of us. Thanks for being here and all the efforts and all the time you spent doing this. That being said, the comprehensive plan was developed obviously in part for situations such as this. And the attorneys that included a letter here from the combined submittal say that it considers the needs of all citizens, business, and the environment. And objective number 2.1, the self-storage facility within the C2 zone provides a diversity in land use while providing a high design and aesthetically pleasing project. Now, I saw the diagram and the pictures that the applicant posted for you. That is not included in the combined submittals. What's included in the combined submittals for tonight is this, a purple building. Those photographs, those pictures, those schematics that they showed a moment ago all pertain to the last time we were in front of you, when they wanted to have a storage facility combined with a retail office complex and a clubhouse. And by the time it got to the city council, they removed the clubhouse, they removed the office usage, and they removed retail. Tonight, you saw them bring this up again, and with a diagram circled Veterans Boulevard as the area where retail would be placed, or conceivably could be placed. There's no ingress or egress off Veterans. The retail, proposed retail, future retail would be off of 42nd Street. 42nd Street, and I know you've dealt with issues regarding 42nd Street with parking and congestion before, and recognizing what staff reported regarding what this area is like. It is packed day and night. My wife, just anecdotally, and I were riding bikes yesterday, the first sunny day we've had in a while. We had to stop in the Fisher's parking lot, the Boys and Girls Club parking lot, to allow the buses and cars to pass us. This development, and I know we're not talking about a CUP tonight, but it is right across the street from the Boys and Girls Club, right across the street. There's hundreds of kids there every day. And a lot of those kids are from future public school. And to your credit, you moved the crosswalk on Adams from 42nd to 43rd. And also now there's another crosswalk being built on Chinden at 43rd to hopefully encourage people to go down 43rd as opposed to 42nd. But this, as pointed out before, is a vehicle dependent use. They're going to be on 42nd Street, folks. And so to change the zoning, despite the fact that our city is 1.3 miles wide, it's a lot longer than 1 mile. Conceivably, if you were to change the zoning and allow this to be included in the mixed-use commercial zoning, the Ada County Highway District is going to vacate that property relatively soon, certainly within a year or two. That's within a mile. That's not far at all from that area. I don't have the exact amount, but I know it's 2 miles from our Parkway Station unit to Talaya. So conceivably, by including this into a mixed-use commercial district, down the road, you would have limited power to stop future developments such as this. I'm not, my wife and I, we've lived here for 4 years. Our real estate agent was born and raised in Boise. We saw our home on Zillow. We've been looking for a home here for quite some time. My wife says it would be perfect. We call the real estate agent and he says, I'll show you some homes in Meridian. And he did. He did not want us to move here. And he finally divulged to us, oh, this is Garbage City. This is known as Garbage City. We knew better. We knew that Garden City sits on a gold mine. And the gold mine is the river and the greenbelt. We knew better than our real estate agent. And we are just happy to be here because that area looks beautiful. This proposed development, again, understanding the CUP is not in front of you right now, but the change in zoning that would allow that CUP to be brought up to you next month is literally a stone's throw from the river. And I'm not saying that loosely. It is literally a stone's throw. And so I have concerns. I didn't know until tonight there was a proposed retail aspect to this. It's not included in the combined submittals. So even though they pointed at veterans, and I'm sure she made a mistake, innocent mistake, retail on 42nd Street with the traffic that exists now is incompatible, absolutely incompatible. If the applicant would say, look, we're going to use those original photographs or schematics as opposed to this purple mansion, and we're going to take down telephone poles that litter that area, I would love to see those gone. And we are going to work with the city to curb the parking problem, the traffic problem on 42nd Street. And we're not going to have retail that would bring in more vehicle traffic. I would consider endorsing this as a variance of the current existing zone, but not as a rewriting, for all intents and purposes, of the C2 zone, mixed use commercial. I'm sure there's a lot of other notes that I haven't addressed. I don't want to take a lot of your time. But we love where we live. We're here for a reason, so are you. And are hopeful that you'll consider our voices as well as the applicant and make a fair decision on this. I think it's very important to consider a variance, maybe, but not a change in the zoning. We're 1.5 miles wide, but we're 5 miles long, roughly down the river. I think it starts at probably Ling and Louise, and you keep on heading west. And it goes quite a distance. And there's a lot of infill possibilities there, including the ACHD property, that we would then be saying something like this can go there next to the river, which would be crazy. So with that, I thank you for your time. I'm here for any questions you might have.
Thank you very much. Appreciate it.
Thank you.
All right, next for the public testimony is Ian. And Ian Carroll. Oh, does not wish to testify. Let me make sure that I'm calling everybody else. All right, well, it looks like that. Was anybody else here in the audience wish to testify on this item? All right, seeing none, then we will go ahead and return to the applicant's rebuttal. Mr. Hatch.
Do I have to share the screen again? Jeff Hatch with Hatch Design Architecture, 200 West 36th Street, Garden City, Idaho, 83714. I appreciate the commission's time this evening to review our considerations for this code amendment. From my perspective, when you write code, you got to look at the entire city, the dynamics of what that looks like. And the intent of the code, from my perspective, is trying to address the density needs that we have in this city. Seeing how it's been addressed in Boise and how they're addressing concerns for density, seeing how Nampa is doing that in Meridian, and seeing elsewhere throughout the US, which I'm graced to be able to work, has brought considerations to a project, but not only a project, to a city. And so I know Ms. Germain has discussed the 42nd Street location, but I've been analyzing 3 particular sites here based on this code text amendment to apply it to an overall city code. I'm looking at a corner lot, I'm looking at an infill slot style lot, and I'm looking at a single access road style lot. What we're doing with the design review application for the 42nd, I am then applying to these other locations to see if this is something that is overburdensome to, say, a corner lot versus a single access lot versus an infill lot, to try to make sense of how this rolls out from a city standpoint. What are the greater implications of the code? And are we doing a good job writing it? Or, to many of the comments that Hannah had, are there still things that still need to be fine-tuned, resolved? And in my opinion, a lot of the feedback that we got from design review, we've provided a response to them, but it would be very helpful to go back and discuss with them how that response looks and if they feel that it's an effective activation of their concerns in a way that can be both meaningful for design review, but also for code. So at the end of the day, we want to produce a code together with you, with city council and with staff, that is effective at creating an expectation for future development. But in addition to that, it sets an expectation that meets a need that we see that will continue to be growing in the future. We aren't getting less dense, we're getting more dense. And with that, the types of uses and the nature of those uses change. We see types of product like the Class A storage facility, very common in Portland, very common in Washington, various dense locations. We're starting to see multi-story storage elsewhere in Idaho. And I'm not really a huge component of just looking at storage from a use, but from the use standpoint of our previous project had like half a dozen commercial components to the use. And we had a client who wanted to do that. That was a client's project. In this case, we're seeing the needs and the uses and the desire of the city, the connectivity of that pedestrian, and how that meets the needs of Garden City is really what we want to explore. So I'll let Abby close, but I would respectfully agree with Hannah and say we would like to go back and do better and go to design review and then present our findings if that would be of consideration to this commission. But I'll let Abby continue.
I have a question for him.
Mr. Hatch, Commissioner Brown.
I have a question. I was gonna wait till the end, but you prompted it. So you are, by the last statement, if I heard it correctly, you're suggesting that you would be all right with going along with the recommendation of the staff to give you more time to deal with some of these issues with the staff and the design review. Is that correct?
Commissioner Brown, I'm usually in front of you with a project. Projects have timelines and people squeezing me to make decisions or try to get decisions made. We're not trying to make a decision tonight. We're trying to do something right by the city of Garden City. And if that takes longer,
that's what I understand.
we
I'm
are
just
on
making
board
sure
for
that's
that.
what you're saying.
Absolutely.
Okay, yes, thank you.
Commissioner Smith.
I just have a question for you about not really the details of the way the code is written, but more the overall concept, because I'm looking at this table and what I'm seeing in common with the uses that are allowed either permitted or conditionally in the C2 zone is that they're all things that have a lot of movement. They're restaurants, bars, gyms, shops, coffee shops, laundromats, schools, live work environment. It's movement, kind of like the description in the comp plan talking about these activity zones where we have a lot of flow. And then if you look at what's in common with the C1 and the L1 zones, it's a lot of fixed things, storage facilities, vehicle parking, manufacturing, things that don't really have a flow. People go to them for a purpose. They don't go very often. So I'm struggling with, I think your code is in a lot of ways very well written, but I'm struggling with the overall concept that storage belongs in these activity nodes, in these very dynamic parts of the city. Could you talk about that a little bit and your thoughts on that?
Yeah, so recently we did a project in Boise, and I know Boise's not Garden City, but in that particular case, they wanted more pedestrian access and more pedestrian activation. And so in that particular case, we said, okay, well, based on this location, you have a fair amount of density of neighbors. So we should do a commercial presence on the street facade. And in that particular case, what that does is you get businesses that need storage. And so they're utilizing office space, they're utilizing retail space, but they also need the storage that's within that facility. And so versus having this kind of static thing that you go to maybe once every 6 months or so, this is something that people are going to, operating a business and also utilizing the services of that building on a daily basis. And so that's what we're seeing in Boise, and you know, this need is different and the density is different, but we're trying to make this meet the intent of the C2 code.
Thank you.
Any other questions for Mr. Hatch?
Yeah, I already answered mine.
Mr. Chairman, Commissioners, again, for the record, Abby Germain. I just want to touch on a few points. I'll be really brief. I want to directly address Commissioner Smith's question about, is this type of use appropriate? And I would submit to you, yes. And the reason is because, again, it's not a typical storage facility where it's unvisited, vacant most of the time. This would have components of it that would really bring use and pedestrians and people to that facility. The other thing I think that is really important to consider when thinking about this property is balancing private property rights and the ability to build something in that area, and then deciding what's best for that area. And when we were looking at the options, we thought about a restaurant, we thought about multifamily, but all of that increases traffic. So to the comments that we heard from the public this evening about concerns with traffic, about concerns related to services, we had to find something that we thought engaged, to Commissioner Smith's point, that was bringing in good aspects, good attributes and a commodity to the area, but wasn't a high traffic use and wasn't something that would tax and burden city services. When we originally came to this commission and the city council with the first project, there were aspects of commercial nature in this project. The feedback that we actually received from the public and from others was take that out. We don't want to increase traffic. We don't want to increase burdens on the city. So we did. Now the feedback that we're hearing from the design review consultants and staff is engage pedestrians, bring some of those non-storage uses back in, bring in office space, bring in potential retail and artisan areas for the public. So we're trying to balance those. And I think what we've done, and hopefully the commission will ultimately agree, is a balance of those aspects. One last comment on the standards in Garden City Code, Title 8, Chapter 6B, subsection 5, related to what must be met if we do a code amendment. I was remiss for not addressing that in the first place. I think we are on the same page with staff as it relates to that final criteria, that this is not an adverse impact to city services. The question then really becomes, is this detrimental to the public health, safety, and welfare, and doesn't meet the comp plan? I would submit to you that it does meet the comp plan, and that a code amendment that would facilitate this type of Class A storage within a C2 zone meets many of the goals and objectives, and those are outlined in staff's report. And as you all know, having looked at tons of applications all the time, not every project, not every proposal is going to meet every single criteria and goal of the comprehensive plan. It doesn't meet a majority of it, and is it a good fit? And I would submit to you that this project is. On the second criteria of detrimental to the public health and welfare, comes back to what else could potentially go in that spot. And are we going to increase traffic? Are we going to increase the burden on city services by encouraging the applicant to do something else in the space? So with that, I'd happy to answer any questions, but I will stop talking.
Thank you. Any further questions? Thank you very much. I appreciate it. With that, we will close the public hearing and have a discussion amongst the commissioners. The way that I'm seeing a couple of these items within this decision is we could probably break it down into at least three different, I guess, topics. First being, are we generally good with the amendment itself in the sense of whether or not we'd add it to C2 designation? The other would be, are there specific codes or other codes that need to be considered in this? And then the other is the process, whether it's continued or recommend approval or denial. So I'd be open to discussion amongst the commissioners on how we'd like to go forward with this, because I would say if our recommendation is to deny or recommend denial of the amendment, then we probably don't need to talk about the code itself. So it might be good to understand from the other commissioners where they're at with the amendment itself prior to getting into discussions on code or process. So Commissioner Brown.
Okay, here's what I don't want to deny it. I think I'm very strongly in favor of picking up where Hannah left us with her recommendation. My thoughts are that we should continue this. I think it's an important thing, and I appreciate all the work that they've put in on what they've done. And I have the same concerns which Hannah led us to, even though some of them they've addressed in her memo. And in that vein, I'm thinking that we should continue it. I think it should be continued for 2 months, and this is the reason. That gives them an opportunity, and I'll pick up on what Mr. Hatch said. They're not trying to just push something through, and I kind of think we would be pushing the envelope if we try to push it through in 1 month. And I think that they have an opportunity in that, not only to come back to the staff with those issues that have identified where there already are unresolved questions that the staff has, but then take those and go back to the design consultant, because I would like us to be able to see what his reaction is to the changes that they've made relative to the questions that he had. Within that, one of the specific things that I would have questioned, but this is a better way of doing it. If we do this, if the others would go along with that, I do want to comment that I don't think it has been covered. I agree with the staff with regard to the issue of the 1 mile exclusion. I have a lot of problem with that. It looks to me like, I don't care how you put it, that is doing just what the staff said in the memo, and that's limiting competition so that this particular applicant, I realize we're not looking at the specific application, but that would be enabling, and not enabling, it would give them an exclusive right in a major portion, the way that part of Garden City is structured, and a major portion of what I call the old part of Garden City, where he would have an exclusive right to this type of facility. And I don't think that that's our role to do that. So I'm putting that into being something specific. Should everybody else go along with what I'm recommending, that needs to specifically be dealt with. And then the other things I think Hannah has pretty much laid out that I think they need to talk about. They need to do a little bit of adjusting and seeing what they want to do that. Come in with the staff and then go back to the design consultant, get his comments, and then come back to us before we would be in a position to make a recommendation.
Thank you, Commissioner Brown. Commissioner Shepard?
Thank you, Mr. Chair. I also would support a continuance for further refinement of this, and I agree with everything Commissioner Brown said, specifically the 1 mile exclusion. I looked at the C2 map overlay, and that seems like it's most C2 is in close to within a mile of that. So I feel like if we really are talking about the need for storage with the increasing densities as time goes on, that 1 mile exclusion probably shouldn't be in there. I'm not satisfied with it right now anyway. And I agree with continuing it for 2 months. I think that's also a good amount of time. And then I don't know if we need to talk about it if we're going to continue it, but I'm trying to like wrestle with the traffic situation too, because I guess in that one location, it might be less traffic than like an apartment complex or something, but we're not looking at that actual building right now. We're just looking at the code for the citywide code. So that's where I stand right now.
Thank you.
Able to continue.
Thank you, Commissioner Shepard. Commissioner Smith?
Mr. Chair, I think I would return to what you suggested in the beginning, which is, and maybe it's already been answered by my fellow commissioners by their support for continuance, but I simply just don't believe that storage is compatible with the comp plan. And if storage isn't compatible with the comp plan, then nothing that's adjusted in the code is going to make a difference. And that's where I'm landing. And I already discussed it a little bit before with the list of types of uses that are in this zone versus not in this zone. And I don't feel like there is a gap in the code. I think storage is addressed, and it's addressed in other zones, making it pretty clear that that's where this type of storage, or where storage ought to be. And I think that back to that list that I was talking about, restaurants, bars, gyms, schools, coffee shops, laundromats, all of these are conditional or permitted uses because they really serve Garden City residents that live near and around that area. Storage brings people from all over the place to come and store things at this very nice, sounds like it's going to be a very nice storage facility. So instead of people moving, working, living in this activity node corridor we're trying to create, we're putting a big storage facility that people come and stick their things in. And so my issue is not with the code. In fact, I think the code could absolutely be dialed in to work. And I think it's well-written, and I think we should talk to Mr. Jermaine about writing more of our code, because I think it looks really good. So I don't think that's an issue, but I guess I would just say that if the other commissioner's position is that they do believe that this meets the goals of the comp plan and that it's just a simple matter of tweaking the code, I'm happy to vote to continue to allow for that work to be done, and we can all look at it again. But I would just hate if ultimately it's going to come back and then we're all going to decide it just doesn't meet the comp plan, then that's a lot of money and effort and legal work that we're putting the applicant through that if we've already gotten there, I wouldn't want to do. So I just say if we maybe want to kind of clarify that, I sort of know where I am, but as I said, I'm happy to continue if that will be productive.
Thank you, Commissioner Smith. So I would like to make sure that we are all on the same page, because I do agree with Commissioner Smith on, going too far and then we're just going to deny it in the future. But from my perspective, I do see that this use could fit into C2. Part of that reasoning is that there's already quite a few uses that I think fall similar. I mean, we have conditional use in C2, that's equipment rental and sales and services, fuel sales, hospital, industry flex, laundry and dry cleaning, lodging, that if we're talking about traffic in some of these areas, I think that there's probably worse traffic situations that are involved with lodging, manufactured homes and mobile parks. So the reason why I'm saying that I think that it fits into C2 and there's a distinction between self-storage and this is what the applicant is trying to produce is that there's a way to activate it with having some sort of mixed use on the first floor, which I think does activate it for a higher and better use. Retail is already an approved use, or I can't remember if it's permitted, but it's at least conditional within that zone. So, and I could see that in one of the areas on that table of how do we activate, what does that mean, whether it's a percentage versus whether it's frontage, how do you get the activation so that you do have a distinction between purely self-storage that's just there for people to store versus trying to actually activate that property to have it for a mixed use with some other use that's going to serve the community. Because I think that there probably is a need for storage in certain areas around Garden City with the density that we're trying to produce. When we're looking at some of these developments where you have 14 dwelling units per acre, you're not going to store anything in that. And especially if we're looking at how people are using garages for storage rather than parking, and it's already a small site, like it just seems like if a developer can make it work financially and we can put it into a zone that makes sense, that in my opinion, I would consider it. Now, with that being said, I do think that having it as conditional is extremely important for us, because if we think that it's within an area that it's really not supposed to be, or it doesn't fit the overlay or the district, then we can have that discussion and say no. So as opposed to a permitted use. So I think from my perspective, I would be willing to continue it for 2 months. I would also be willing to, hear how the applicant and staff can work through those items so that when we have the hearing next time, we can decide whether or not to approve or recommend approval or recommend denial. So from my perspective, I would say I'm good with the concept generally. I do think that we procedurally could continue it. I like the 2 months because that gives enough time. And then I don't know if we want to have, provide our comments to code to staff, or if we want to have a discussion tonight on some of those changes that we would consider. I know that there are some of those the text of the code that needs to be changed just so that it is more aligned with code and referencing in code. But also there are some concepts specifically that I think we could get through at least on that scorecard or table, just to give general feedback to staff and guidance. So are we all in, of course, no motion, but just moving forward. So we've had the discussion on whether we would talk about a continuance. Seems like that's the general consensus. And then getting into just some of the general areas of code that we would want staff to focus on. I know Commissioner Brown, you mentioned the 1 mile. I have some thoughts on some of the others. So how about the next, we move into that? Is that okay? Staff, would it be possible for you to put up the scorecard just so that we can easily reference that when we're talking through some of the items?
While she's doing that, Mr. Chairman, I would like to bring something up that I probably should have before that, so it doesn't get involved, at least in my opinion. One of the items that's been brought up by everybody that's testified has to do with the traffic problem, as that being how this would contribute to that or not contribute to that. There are 3 of us that are sitting at the table that just recently walked over that area when we walked over that area looking at the traffic as an issue. And so within this applicant or any other applicant is not going to be able, and I don't think we should expect them to solve the problem of traffic on 42nd Street. Those streets all along there are one entrance into the street, and then they butt up against the river. So you only have one direction that all the traffic goes in, comes out. What's on 42nd Street comes out to Adams. And when you think, just look in the C2 area of the different kind of items that could go in there. This development, that if it gets approved in that, will not make it any worse, and in a lot of ways less worse than some other things that could go in there. So I don't think that we should be trying to force something into the code that would require the applicant to solve a problem that I don't think can be solved. 42nd Street is stuck in there between Veterans and the street that we do want people to use more for pedestrians than that is 43rd Street. That's why the light that's being constructed right now is being put in there. So anyway, I thought that is something we should consider when we're talking about this.
Okay.
Mr. Chair, I'll just add that I absolutely agree with Commissioner Brown. Hitting that second point of detrimental to public health or whatever that was, I don't believe this, adding this to C2 would be detrimental. If anything, I think parking would be reduced from some of the other uses. So just for the record, I don't think that particular prong is a problem. And I agree that there are just some problems that can't be solved. And I actually think something like a restaurant or retail might generate more traffic than a storage facility. So I think that's worth considering, and I agree.
Thank you. With that, is there any other conditions in code that you would like to talk about that you had an issue with, or that you have any comments for staff and the applicant to work through?
I agree on the 1 mile exclusion. I don't think we should have it. There's one other. No, that's okay. My eyesight's holding for now.
And Commissioner Smith, did you think that the table and the memo was actually better? That might be
Maybe
easier.
that might actually be better.
Yeah.
The ground floor activation, agree that facade only. I mean, if the idea is that we're looking, it's about appearance, I don't think it should matter what they do inside it. Are you pulling up the other one?
Yeah.
Thank you. And then the biggest one, Mr. Chair, you already mentioned, I think just making sure it's conditional and not permitted, so we can address it the way we would any other development of that kind. Those are the only ones I can think of off the top. Particular views.
And just because you're bringing them, I'll go through some of mine and then turn it over to you two as well. Since Commissioner Smith brought it up on the activation. So The question that I would have is how to activate the first floor where it's actually affecting the public potentially, as opposed to, because some of these storage sites can be pretty deep. And so I don't know that we want to prohibit storage on the first floor altogether, but just in certain areas. And that's where I don't know if it's a percentage or if it's just a frontage. You had mentioned that Boise did something, so maybe work with staff on what does that look like when we're talking about how to activate the first floor. I think it would be hard potentially on a percentage basis, but let's talk about different options there. Other zoning districts, it seems like, in my opinion, if we're approving it for C2, why not approve it for L1 and C1? It seems like if you can have a nicer facility in those two districts, it would work. I'm not resolved on the 8-2B-4. I'll defer to others on working through that. The overlay, I think that we touch on when we were talking about having the discretion through the CUP process and approving it in appropriate districts. I don't know if we need, and then that ties in with the future land use designations, whether or not we need to have some sort of note or something within the code that just says to consider other overlays and decision-making. And then adaptive reuse, structural flexibility. For me, I don't agree with this. I think that there are so many different uses that it would be hard to tailor the building and to constrain it to some other standards that we have no idea what a future use would be. And then the ground floor storage use prohibition, I would be okay with certain portions of the ground floor being used as long as it's not the entire floor, especially for activating a portion. So Commissioner Brown.
So I would agree with all of those, especially, and that I already mentioned, and with what you said, and I want to support your idea, especially when you look at realize that it's not the specific thing, but we know what the size of building we're talking about. And that's going to be a fairly large footprint of building just because of the parcel that we're using. And I agree, it wouldn't be necessary on that. First of all, when I looked at ground floor activation, I had to call Hannah and ask her if she could explain what that was to me. Anyway, so that I agree that you can have what you're envisioning to do there without making the whole floor subject to that. And I'm not sure whether you want to do it a percentage or just limit to the front row of office spaces or whatever. But something like what you suggest would satisfy me. And I agree with the other comments that you made.
Thank you, Commissioner Brown. Commissioner Shepard.
Thank you, Mr. Chair. So I already talked about the 1 mile exclusion and how I don't think that should be in there. And I also agree with the chairman about not having the structural flexibility requirement in there necessarily, since we don't know what would go in there in the future if there was going to be something, and we're talking about the whole city. And I don't see it on the scorecard from today, but from the memo, and you mentioned it too, talking about the other zoning districts. I mean, I think that the Class A should go in the other districts as well. And I guess just as a comment, as far as like, I don't know exactly where it would fit into this categories, but with the density that we're trying to build in Garden City and also the outdoors, like I'm just thinking like people with their kayaks in the Whitewater Park and living near there, like I can see a use for storage in the C2 area of the city for those reasons. So I think I don't really have a comment right now on the 3 acre, 130,000 square feet thing. Like, I just need to see that in a different way from how this is. That was like, that limits it to 3 acres, right? So if it goes, oh, if there's like a bigger lot, you can't have them there. Is that right? I don't know that we need to have that in there. I think those are my comments for right now.
Okay, thank you. So procedurally, oh, Commissioner Smith.
Oh, I was going to say, Mr. Chair, do we want to address 2B4? I think that's the dwellings requirement, right?
Yeah, there's three parts to that.
There's three parts, and it's essentially the one that would apply here. It says for developments with a site of 120,000 gross square feet or more, at least 10% of the square footage must be dedicated to dwellings. But then number 3 says that developments that do not meet the above criteria may be allowed, provided approval of a conditional use permit. So I'm not sure that really even needs to be addressed, because I feel like it already is. It says it's a requirement, but basically we can nix the requirement if there's a conditional use permit, which there would be since it's a conditional use. So I don't know, is there a reason why that needs to be addressed at all in this code?
I would defer to staff on that, but I go ahead, Ms. Veal.
It is not necessarily needed at this moment to be addressed. It's just something to be aware of.
Okay.
I guess I would say I don't see any reason to specifically exclude this use from the generalized code. So it would just fall into the same bucket as any other conditional use.
Mm-hmm. Okay. Thank you, Commissioner Smith. As a procedural matter, if we're going to continue this, do we need to have a motion that includes reopening the public hearing?
Chairman, you read my mind. I actually have that noted, and I also wanted to note that 2 months from now is June 17th.
And then just for the sake of staff, is there any questions that you have for us that you want us to work through, or that it's not clear on what we're looking for that you would want to work with the applicant on?
Mr. Chairman, I think you have covered all of it. I think the most vague, moving forward is the activation. What I'm hearing from you tonight is don't prohibit storage from being on all of the first floor, maybe just a percentage or a ratio, but not the whole thing. So that'll be up to staff and the applicant to work through with the design review consultants and amongst ourselves.
Yeah, it makes me think of some of the mixed use, like Crosshatch, where you have, or maybe it's across from Crosshatch, where you have the retail on the first floor, the barber shop. And I don't know what the code says in relation to how you mixed that into it, but it looks like it's activating. You have the mixed use, you have that option to some degree. And I don't know what the metric is for it. That's right.
Okay. And then a follow-up question would be, we discussed tonight the definition of this use and the existing self-service storage uses. Is that something that needs to be further hashed out into additional classes, or what does that look like to the commission?
Commissioner Smith?
I had that on my notes and then I forgot to address it. I think that we ought to call it something different, because I don't think we should be moving general self-service storage into C2. And so I don't feel like calling it Class A is enough. I mean, to Ms. Veal's point, unless we want to provide a definition, but I worry that that definition is going to be too restrictive. But I'm wondering if we could build the activation and some of the things we're thinking differentiates this from a traditional self-storage unit into the definition, rather than having it a separate part of code. So rather than saying, when you build this, it has to activate in this way and there can't be this in the ground floor, maybe the definition of this type of storage facility just has that built in. So the definition of Class A, or what you want to call it, storage facility, has, I don't know, 30%, whatever, ground floor activation, retail, that sort of thing. So I'm wondering if maybe we can cut out some of the code work and pull it into the definition. It may be simpler and give us an actual definition.
Mm-hmm.
Just a thought.
Yeah, I would defer to staff to work on that.
May I make a comment?
Please.
Just in brainstorming this too, how would the commission feel about requiring certain design standards in addition to what's already in 8.4C, which is the commercial design standard? So it requires glazing, like that pedestrian activity kind of orientation. Maybe if a future storage self-service use gets proposed in a particular zoning district, it would require additional design standards under 8.2C. So we're not necessarily making a whole brand new use, but requiring more like pedestrian activation under like a C2 zoning district versus the LI, like industrial zoning district.
I think it's going to be hard to distinguish some of those characteristics in certain situations. You know, in this one, I think we have a vision of it, so it's easier for us to kind of couple with. But I could see a situation on a self-service where they try and get through the loop by just putting in, you know, a small shop on the corner and saying that now it falls into that classification. And then they're happy to do the design, but effectively it's just self-service, single story, drive up behind everything else except the office. So I'd be careful just with that. I don't know the solution, but maybe if there's a couple different options that we could look at or consider, whether it's definition, whether it's actually code itself that would prescribe effectively what class A would be without calling it class A.
Help you there.
Yeah, I do think we could create a bunch of future problems if we don't define it well. Because we can't just put a picture of this facility in code and say, do this.
Right.
Yeah.
Even though that would be the easiest. So I think maybe we just need to think about what are the core components of what makes this work in C2. You know, obviously in a conditional use discussion, we're going to be talking about trees and where they get planted and how many bushes and all that stuff. But what do we want to not be discretionary? I mean, I think that's maybe the question. What shouldn't be discretionary? Because in the conditional use discussion, there's a lot of discretionary things. And so, for example, that activation is having a percentage of that bottom floor be for a certain thing. Is that something that just has to be universal? We don't want it to be discretionary. We don't even talk about it. It just is part of the rule. Or is that something that, depending on the project, you know, could be malleable? And I don't have any immediate answers, but I think just kind of coming up with that core list of what makes this different, what makes this okay. And, you know, maybe we even think about it like a subdivision where you think about, you know, I don't know, access or open space, or it can't just be a giant square. So I guess I just put those thoughts out there of what are we really trying to achieve at its core? Because I think also, if we are going to allow this, we don't want to clutter it up to a point where it's so oppressive that, you know, this particular use is just so bogged down with rules when every other use is, you know, kind of
Like you said, we don't want to take this example and this picture, whether it's purple or red, whatever color it is, and say, well, this is what they all got to look at. You don't want to do that.
Right.
It's not like you're taking a subway building, right? And say, all right, it's all got to look like this particular building. That's not what you want to do.
And I mean, maybe it's enough of the footprint that with this particular use, there's a limited footprint that it can only use X percentage of whatever lot it's being built on. You know, that's another way to look at it. And maybe that makes it less colossal if that's one of the issues. And
yeah.
So, you know, I don't know, maybe if it were me, I would just list the problems I anticipate and then figure out what rule would fix them, but.
I wonder for like a class A urban storage facility, like the individual units would just be smaller than like something you wouldn't pack your whole house into there and have big trucks moving in and out. It would be more like what you put in a pickup truck or a minivan. I don't know if that would be something that we want to.
I like calling it urban storage facility. That sounded kind of.
That might be a good
I
idea.
kind of like that word, urban storage, maybe.
As differentiating it from the industrial area.
Yeah.
Where you have your other regular ones where they fit in, right?
Well, and I think that the applicant could probably help
Yeah, they might
with
help.
some of the
Give us some help.
distinguishments. I think just from a practical standpoint, there's differences between drive up, climate controlled, multi-story, right? And so it's going to be more than likely not a drive up because that's what we're trying to avoid in the self-service. So it's going to be some sort of climate controlled, potentially a multi-story. And so if you're avoiding that drive up, you're really changing the site use to make it more of a facility as opposed to multiple small buildings. So I would just work with the applicant to see if you can come up with something creative to help us with that.
Okay.
All right, so as for the motion, it sounds like the commissioners are all in agreement that of the continuance, potentially that continuance is for 2 months. Applicant work with staff on the items that we've discussed today, and that we would need to reopen the public hearing so that we can continue that for the date certain of
June 17th.
All right, so without any further deliberation from the commissioners? Hearing none.
You need a motion or not?
Yep, we'll entertain a motion at this point.
I think I could probably get one.
Commissioner Brown?
Okay, I move that we continue CPA FY 2026 #1, a code text amendment to a date certain of June 17th. All right.
I believe we're going to need to have the motion include reopening the public hearing.
And that would include reopening the public hearing to have a public hearing.
I have a motion. I have a second. Any further deliberation on this? All right, we'll take it to vote. All those in favor say aye.
Aye.
Any noes? No noes. Other items on? At this point, there are no other items on the agenda. Anything else for discussion amongst the commissioners? All right, with that, we'll call the meeting adjourned. Thank you very much.